Alex here with part 10 of the My Docket series on Corazon real estate. In this video, we're going into my opposition to the landlord's motion to dismiss. I keep calling him landlord, property manager slash landlord. I'll talk a little bit about this during my mindset because I really can't remember how I felt about it. I'm sure I felt confident because I understood the standard on motion to dismiss, but it'll probably be better for me to talk about that here rather than through the document. Through the document, I'll try and go through the lines a little more quickly. Anyway, what your opponent's trying to do is say that the claims or allegations you have made are insufficient to warrant relief, and that the case can immediately be terminated right at the beginning because what you're asking for, what you've alleged, even if true, doesn't warrant you to any kind of legal relief. And I talk about that in the video. I think I call it early case termination. That sounds about right. And there's a few mechanisms I believe that are available for that. The importance of talking about this now is that in the actual portion of this video where I go over my opposition, you'll notice that I'm not really focusing that much on who has more proof, who's more believable, who's right and who's wrong. I'm focusing on whether I have alleged facts that, if true, entitle me to relief. It's just a pure analysis of the allegations, the claims that you're bringing to the court, and whether the allegations that you're making satisfy the elements of those claims. A whole lot more detail in the video early case termination. Please watch that video if you haven't seen it, because I'm not gonna go too much into it now when I've already done a separate reference video for it. Really, I think at this point all we can do is go ahead and take a look at what I have filed. Here we have my opposition to property manager, we'll just call him Corazon Real Estate's motion to dismiss. Standard introductory paragraph indicating I am appearing in improper person, which means I don't have an attorney, and I'm filing an opposition to Corazon Real Estate's motion to dismiss my case. Factual background. Well, I guess that this can be in here. September 20th, I filed my complaint. October 12th, they filed their answer and counterclaim. October 15th, I filed my reply. Okay, so these are the briefs. The first three lines here are addressing, not the briefs, sorry, the pleadings. Then we have the October 17 motion to dismiss, alleging that my claim for punitive damages is a sham to establish subject matter jurisdiction. Now, the landlord didn't use this language. I am using it because this is the language that's used in some Supreme Court precedent that I looked into. So I basically converted what he was saying into this phrase, which he's trying to say that if not for punitive damages, I don't have, the ability to use the district court. I would have to be in justice court, which is true, if that's true. And he's also saying that he wants this case to be filed as a small claims action. And I do have to address these. These are decent arguments. I mean, a lot of what he said was nonsensical, but I converted what he said into two things that I thought the district court and the Supreme Court later on would be interested in. So he fails to cite any authority. DCR 13.2. Let's see here. Okay, yeah. And that's true. I remember when we went through his motion, there were no citations to statutes, rules, or case law. So I'm using Rule 13 sub 2 against him. And then we've got a case where the Supreme Court mentions when there's no authority in support of an argument, they just don't even consider it. It looks like the other case, same thing. Basically, the Supreme Court's complaining that they were supplied with two pages of conclusory arguments, lacking any substantive citation to relevant authority. And it's important to do this. If you don't do this, you leave yourself wide open to losing and not having any ability to appeal. Let's see. Whether he's committing unauthorized practice of law. Well, I guess this is one side of the coin. which is that a non-attorney cannot represent their corporation. But I don't think they're going to look at it through the unauthorized practice of law lens. I think that they're going to look at it as a person trying to represent his corporation. So I get what I'm using here, but I think this is the lens that the district court or the Supreme Court takes. They do actually rule in my favor on this point. They just don't call it unauthorized practice of law. They just say that an officer cannot represent their corporation. I cannot be forced to file a small claims action. So this is actually a decent argument, because this is an argument that actually worked for a while in Nevada. There were a bunch of justices of the peace who were saying that if you are asking for an amount lower than the threshold, then you have to file a small claims action. You cannot file a civil action. You're just not allowed to do that. And eventually went to the Supreme Court, and the Supreme Court disagreed. And they talked about this in the case Aftercare of Clark County versus the Justice Courts. And they determined that the justices of the peace, let's see here. We consider whether justices of the peace may deny jury trials to litigants who filed a civil action in justice court rather than a small claims action and seek less than $5,000. The Las Vegas Township Justice Court has implemented a policy denying jury trials to litigants unless $5,000 or more is at stake. The district court declined to issue extraordinary relief, compelling the justice courts to allow the jury trials for the appellants, who are the defendants in 2 justice court civil actions involving less than $5,000. The reasoning, I remember, if you go more into this case, is that they said, you should just file a small claims because it's under $5,000. That's just what you should do. But the Supreme Court concluded that the Las Vegas Township Justice Court's policy violates the constitutional guarantee of a trial by jury. And so they reversed the district court's orders that denied appellants petitions for writ relief, and they remanded cases to the district court for the issuance of the writs of mandamus. So basically, the Supreme Court told the district court, you were wrong in denying writ relief. You need to issue those writs, and you need to command the Las Vegas Justice Court to compel jury trials in the cases that they tried to say should have been filed as a small claims case. Okay, so if Corazon was unsuccessful in attacking the subject matter jurisdiction of the district court by dismissing my claim for punitive damages, the case would still be removed to justice court as a civil action, not a small claims action. In other words, because of our constitution in Nevada and because of the Supreme Court of Nevada's ruling on this issue, you can't force somebody to file a small claims action just because the amount is under the threshold. You just can't do it. Standard of review on a motion to dismiss. So this is what I talked about earlier in the video. If you're trying to dismiss a case, the review on that motion to dismiss is not what a lot of people think. They're not just like looking at who's more believable and who has a better argument and who has proof. It's way too early in the case, way too early. They're just looking at the claims, they're looking at the elements of those claims, and they're looking to see if you alleged sufficient, allegations that would warrant relief under those claims. And that's what they say here. The task is to determine whether or not the challenged pleading sets forth allegations sufficient to make out the elements of a right to relief. In making this determination, the allegations in the complaint must be taken at face value and must be construed favorably in the plaintiff's behalf. The complaint cannot be dismissed for failure to state a claim unless it appears beyond a doubt that the plaintiff could prove no set of facts which, if accepted, would entitle him to relief. Motion for involuntary dismissal of an action may only be made after the case of a plaintiff's case on the ground that upon the facts and the law of the plaintiff, that the plaintiff has failed to prove a sufficient case for the... Oh, this is different. I don't think this is a good citation. In ruling on a 41B motion, the court must accept the plaintiff's evidence as true. I think this is what they use in the actual hearings themselves. I think this is what is used when, the plaintiff rests their case in actual open court, and then the defendant says, wait a minute, I'm not going to start my case yet. I'm first going to argue that their case right now is not good enough and that they have failed to bring sufficient evidence based on the actual case itself. So I have a suspicion that this 41B motion is a citation to a different mechanism that I shouldn't be citing it. This top one up here looks like it's relevant. I think what I'm looking for is a 12B. There it is. Okay, this is the one. So this next citation here discusses the standard of dismissal under 12B. So this is what I was thinking about. It's rigorous, as this court must construe the pleading liberally and draw every fair intendment in favor of the non-moving party. All factual allegations of the complaint must be accepted as true. A complaint will not be dismissed for failure to state a claim unless it appears beyond a doubt. Okay, so this is what I was talking about, and it's really it's Rule 12b that the opponent is supposed to be citing. They never cited it, but that's what they were supposed to be citing. Argument in support of punitive damages. So this is the other argument that I thought made sense from the Corazon Real Estate, and so I decided to address it. With the above mentioned standard of review, all facts, allegations, and evidence shall be assumed true, and the concept of punitive damages rests upon a presumed public policy to punish the wrongdoer for his act and to deter others from acting in similar fashion. Net worth evidence was received to aid the jury in deciding how large or small its punitive damage allowance need to be to promote the mentioned policy. The plaintiff has already been made whole by the allowance of substantial compensatory damages. Her further enrichment by the collection of additional damages labeled as punitive has to be justified on the ground of public policy, and not for the reason that she has a right to such claim. I talk about this in the video, punitive damages. Definitely take a look as I go into more detail. So as a landlord, Corazon's obligation to maintain the air conditioning and appliances is statutory. While it may seem reasonable at first blush to simply refund the monies, such an award actually incentivizes the continuation of the policy to violate the law. The court must consider that in actuality, very few individuals actually sue to recover monies when wronged. For example, if 100 tenants are forced by Corazon to pay maintenance for the air conditioning and 5 sue in order to be made whole, Corazon would still reap the profits of the remaining 95. Corazon would have every reason to continue its conduct. By awarding punitive damages, Corazon would no reason to continue to ignore the law, because any profits it reaps on the tenants who never sue are erased by the court's punishment. This is the point of punitive damages. They talk about this in another case called Hansen v. Harris. It's an interesting case because it talks about a casino who actually made a policy that if you filed a workman's compensation claim, then you would have to choose between continuing to work for your job or just taking the claim and moving on. In the absence of an injury resulting in permanent total disability, most employees are going to be constrained to forego their entitlement to industrial compensation in favor of the economic necessity of keeping their job. It would not only frustrate the statutory scheme, but also provide employers with an inequitable advantage if they were able to intimidate employees with the loss of their jobs upon filing of claims for insurance benefits as a result of industrial injuries. So they are asked to rule upon the availability of punitive damages in an action for unlawful discharge in retaliation for filing a workman's comp claim. And they have held that, as with any intentional tort, punitive damages are appropriate in cases where employees can demonstrate malicious, oppressive, or fraudulent conduct on the part of their employers in accordance with the law. Indeed, the threat of punitive damages may be the most effective means of deterring conduct which would frustrate the purpose of workmen's compensation laws. Same thing here in my case. If the landlord just threatens to evict you for, holding them to the law, a lot of tenants are going to say, the law is nice, but I'd rather just keep my home. I can't get evicted right now. So I'm trying to argue that this same sort of principle applies here. With the eviction threat, I stated before, without the threat of eviction, I do not believe I had a punitive damages claim, because there would be no oppression. If the landlord just said, or the Corazon Real Estate just said, you know what, this is a decent argument, we're just going to set this aside until after you move out, and then we'll figure out how to deal with it, that would be different. I don't think that I could get punitive damages. But for the landlord to say, we're going to just throw you out of your home, they know that they are using their leverage and their power in favor of their position, which is that they can violate the law. And they know that if they do this to several people, most people aren't going to say, okay, what you're doing is legal. They're going to say, okay, we don't want to get thrown out of our homes. We don't want to get evicted. So that's the key here, is that they're using that mechanism to coerce compliance. In this case, the Superior Court acknowledged the true competing doctrines, namely that Nevada's at will. Okay, so this goes more into, I'm not going to spend a lot of time on this. You guys can read this if you'd like to. I'm going to try to keep these videos focused on the actual dispute. This is just an analogy that I'm drawing between the Hansen case and what's going on in my case. The relationship between punitive damages and the compensatory damages they flow from is irrelevant. That's true. And that's because punitive damages are based on what it's going to take to stop the tortfeasor from continuing to, in this case, violate the law. It's not based on the amount of the actual injury that they caused. The objective of a punitive damage award is different. And this case up here goes into the fact that there's no relationship between those. And then there's a second case here which says that what happened here? Appellants contend that the award of punitive damages in the amount of $30,000 was excessive. We disagree. A district court jury made an award to the Penrods in the amount of $2,000 in compensatory damage and $30,000 in punitive damages. Punitive damages are designed to punish a wrongdoer for their act and to deter others from acting in a similar fashion. Furthermore, the amount of the award of punitive damages need not have a particular relationship to the amount of compensatory damages. Now, this isn't entirely true anymore because of new statutes that the legislature enacted. I mean, if you're just looking at case law and the principles of punitive damages, then yes, you don't really need to, you don't have to like tie them together. But I think it came after the McDonald's hot coffee case that the legislatures of all 50 states took a look at finding ways to cap these awards. And so in Nevada, if I remember correctly, they've capped the award of punitive damages to triple the compensatory damage award unless it's less than $300,000, in which case the court can award $300,000. So definitely take a look at the video Hot Coffee on Netflix. It will totally blow your mind just how deceived and duped the public was. And basically, my opinion is after watching that McDonald's and other large corporations ran this huge campaign to basically take away one of the public's most important swords to punish violations of law. And what they did was they just tried to paint the lady as greedy, and they tried to paint anyone who was like her as greedy. And I think that what they did is just invoke the sort of jealousy that people have towards these news stories where people sue and get these huge $1 million awards. And I think that it works. And so now there's these punitive damage caps. I don't think there should be any caps on these punitive damages awards. This is one of the best ways to keep companies from abusing the profit motive. In this case, the punitive damage award was 15 times the amount of the compensatory damages, while Corazon can claim financial annihilation in support of an argument of excessive punitive damages. It cannot rely on the relationship between the punitive and compensatory damage award. It's also notable that if the legislature intended for there to be a proportional relationship between compensatory and punitive damages, that it would not have enacted NRS 42.005 sub 1b. Okay, I wonder what that... Okay, yeah, I just told you guys about this. Sub 1b allows up to $300,000 if the amount of compensatory damages is less than $100,000. So basically, I can get up to $300,000 because the legislature said so. And if they didn't enact the statute, then the sky would be the limit. Corazon's conduct supports a finding of oppression and malice, the Nevada Supreme Court discussed. I'm glad that I'm bringing up the case law, that this is relevant case law, but I should also be pointing out my allegations, and I didn't do that, it doesn't look like. Okay, no, I kind of did. Yeah, I did. So I'm referencing here my allegations in my complaint. These allegations support that I would be entitled to the relief that I'm requesting. Right, okay. Any provision in Corazon's contract obligating me to maintain the air conditioner violates 118A sub 290, 118A.290 sub 1I, and is therefore void. That's right, because unconscionable or illegal contracts are unenforceable. The legislature reinforced this principle with 118A.220, which states that any rental agreement which provides that a tenant agrees to waive or forego rights or remedies afforded by this chapter is void as contrary to public policy. Wow. So the Nevada legislature even created an extra law just to rub it in the judge's face that, hey, if a landlord makes somebody sign an agreement that is contrary to the law, it's void. I mean, I don't know how much more clear you can be. And the judge just did not comply with this. In any event, if Corazon's contract were not declared void, the maintenance provisions of the contract are ambiguous and contradict each other. So here I'm trying to argue ambiguity in the contract just in case the law won't save me. The judge doesn't even go into this either. Nowhere is the air conditioner mentioned. Furthermore, the lease agreement at page 4 states that no repairs, alterations, or paintings of any kind of the premises shall be made without consent of the owner. consent of the owner. So here's another provision of the contract that's contradictory. And then this is one of the most well-known contractual doctrines, or not doctrines, I guess principles, which is that any contract is construed against the party who drafted it or prepared it. So since the landlord prepared the contract, any confusion, any ambiguity should be construed against them. And here's another case that says the same thing. So the question becomes, can Corazon claim it didn't know its contract was void or ambiguous, and therefore the intent behind oppression and malice necessary for punitive damages is lacking? The Supreme Court of Nevada actually discussed the incentive that this would establish in Ainsworth v. Combined Insurance Company of America. I actually really like this case because I suspected that this was what they were going to say is, okay, so we wrote an illegal contract. We didn't know. Sorry. Well, the Supreme Court actually said in this case, combines obstinate and unjustified refusal to pay, in our opinion, constitutes oppression as contemplated by the statute. The evidence establishes that the Ainsworth were in desperate need of funds and that Combined had reason to know of their dire circumstances. The record clearly supports an inference that Combined consciously disregarded the rights of its insured by clinging to its restrictive definition of accident as used in its policy. The insurer may not rely on its own ambiguous contract as the sole basis for denial. To allow such conduct would only encourage ambiguous contracts. Therefore, we conclude that the jury's award of punitive damages was supported by substantial evidence. So yeah, you can't go in and say that you made an ambiguous contract and you just didn't know, because all it's going to do is just make you write ambiguous contracts on purpose, because you'll be able to get away with this kind of stuff. So the Supreme Court didn't side with them. And then we have the declaration of Alexander Falcone. This is just me saying that I have read the opposition and the contracts are true and correct. And then we have certificate of Rule 5 service indicating this document was mailed to the landlord. List of exhibits, just a notice it looks like. To the landlord, receipt of demand for maintenance of the air conditioner, obligation as landlord. I don't really think I needed this. I should have just been relying on the complaint. Okay. Going into the aftermath, I filed one document. It was a free filing, so I incurred $0 in costs. The Corazon Real Estate didn't file anything, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. Corazon Real Estate's attorney would have probably reviewed this, but at the time that they would have reviewed it, they wouldn't have really had anything to do with it. It would have already been disposed of. So I think it's reasonable to say 15 minutes, which at the rate of $250 an hour comes to $62.50 in attorney fees for Corazon Real Estate. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.